This session is from ASF's 2024 conference at RMIT Melbourne with Julian Gillespie, Augusto Zimmermann, Stephen Moloney, Paul Santamaria and Eamonn Mathieson.
Julian Gillespie is a lawyer who wrote the legal opinions and prepared the briefs for the COVID proceedings before Federal Court and then the High Court of Australia, seeking to show the decisions to extend COVID non-vaccines to children and then babies were always invalid at law. As the Secretary of Health lacked the legal power of those decisions, which legally invalidate COVID decisions, ultimately resulted in thousands of preventable deaths and injuries. Julian researches extensively on all matters connected to Australia's response to SARS-CoV-2, drawing attention to the fact that Australian governments collectively jettisoned years of science for correctly responding to a pandemic, to instead follow unscientific WHO recommendations which favoured big pharmaceutical interests. His other ongoing research includes the failings of APRA, which investigates, whose investigations will hopefully provide victims of COVID-19 vaxxers new avenues for legal redress for their injuries and legal pathways for those families who have lost loved ones to the COVID-19 injectables. His current proceedings in the Federal Court now have Pfizer and Moderna as named defendants for to obtain GMO licenses for their COVID-19 injectables, which these failures amount to serious criminal offences. Sorry about that. That's what I was asked to read out, but Julian, please welcome him, and it'd be very interesting to hear what he's got to say and update.
Well, thank you, everyone. I'm currently short of breath because I'm just rolling out of another bout of pneumonia. So that introduction, thank you, Eamonn, was very kind, but it also failed to mention a partner in professional crime is Katie Ashby-Copen sitting up there. And of course, I don't think is with us today, but all not possible without Katie. Okay, let's launch into it. Ladies and gentlemen, esteemed colleagues and concerned citizens, today I address you with a heavy heart, but with resolve to speak the truth about the catastrophic failures in our legal system. Failures that have betrayed the Australian people and compromised the very fabric of our democracy. These failures are not just legal or procedural missteps, they are moral lapses, breaches of the public trust, and outright of the rule of law. The judiciary, once the cornerstone of fairness and impartiality, now operates under the shadow of undue influence by the executive branch. This encroachment has obliterated the doctrine of the separation of powers, a fundamental principle designed to protect us from. Let us examine two egregious examples of this failure, the AVN case in the Federal Court and the Australian Babies case in the High Court. Both cases sought to challenge the critical public health decisions that have led to widespread harm, including preventable deaths and injuries from the COVID-19. The judiciary, rather than providing a platform for these concerns, dismissed the cases on the flimsy ground of standing. This legal technicality, weaponised to silence dissent, has become the judiciary's shield against accountability and further shield to deny Australian citizens call branch to account. It is a betrayal of the public's right to justice and a denial of our ability to hold those in power accountable for policies that have devastated countless lives. But perhaps no case exemplifies judicial malfeasance, and I'm not sure if that's the correct, and the outright abuse of the legal standard of standing more than the GMO case, presided over by Justice Helen Roth. This case sought to expose how the COVID-19 non-vaccines laden with synthetic DNA fragments likely qualify as genetically modified organisms despite presenting robust scientific evidence and a clear public interest in determining the safety and legality of these products, Justice Roth manipulated the standing doctrine in a grotesque caricature of itself. She effectively ruled that no one, no citizen, no scientist, no affected family has a case unless, of course, you are the minimum wage courier driver Helen Roth surrendered up as a parting comfort for everyone disappointed with her judicial sleight of hand. Helen's decision was not a mere misstep. It was deliberate suppression of accountability of Australia's right to seek justice in a matter of grave public concern, knowing, as she did, the GMO case and the AVN case and the babies case preceding it have run only due to the concerns of thousands of donors demanding our shades of criminal COVID governments and bureaucrats be account. The outrage that followed Justice Roth's decision was palpable. Tens of thousands of Australians, including doctors, scientists and academics, voiced their anger. The Section 72 petition garnered 9,767 signatures demanding a commission of inquiry into her, particularly her very intentional failure to disclose her past and very lucrative relationship with who else but Pfizer. But instead of addressing this public outcry, the judiciary closed ranks. Justice Deborah Mortimer, Chief Justice, or simply Deborah, as she has always been known, a colleague of Helen Roth, dismissed the formal complaint against her with a contemptuous disregard for the appearance of bias, let alone the intentional act by Helen Roth in concealing her past relationship with Pfizer that evidenced only a compromised judge unfit to hold office. Deborah, conflicted from the pinned her colours to the mast in a decision that can only be described as an egregious example of judicial self-preservation. The reasonable observer, you and I, central to evaluating judicial impartiality, was trampled underfoot, or as I have been known to, the bus. Deborah's dismissal spat in the face of established legal precedent and demonstrated the judiciary's willingness to protect its own, no matter the cost to public trust, let alone public health, let alone the lives of Australians. These actions betrayal of the judiciary's duty to act as a check on power and to uphold justice without fear or favour. The Australian public is left to wonder if the courts will not hold their own accountable, who will? The judiciary has not only failed to address the legitimate concerns raised by of Australians, but has also sent a chilling message to those who seek justice in the future. Do not bother, you will not be heard. Australia's legal system now stands at a precipice. The dismissal of the complaint against Justice Roth by Chief Justice Mortimer, the perception that our courts have become an unassailable fortress, immune to criticism and accountability. This systemic failure undermines the rule of law and deepens the already vast chasm between the judiciary and the people it is meant to serve. The very people who pay their $500,000 salaries, the perks and protections they enjoy for not performing their job. Australia's excess mortality, as reported by the ABS, shows an unprecedented rise in deaths, yet our institutions refuse to connect the dots. The Senate whitewashed its inquiry into excess deaths while the judiciary gave Australians their day in court. These acts of denial and evasion are not just failures of governance, they are an assault on the public's right to truth and justice. When the legal system becomes an accomplice to these failures, trust is shattered and integrity is lost. Let us not forget of Deputy President Dean, a judicial officer who dared to uphold the principles of justice in a COVID-related matter. For her courage, she was sanctioned, subject to re-education, and effectively exiled from presiding over similar cases. Such actions are a chilling reminder that within the judiciary, dissent is punished and independent thought is stifled. The erosion of trust in our legal system has profound consequences. When the judiciary aligns itself with the executive, the checks and balances that underpin our democracy crumble. The role as a guardian of justice is replaced by its function as an enabler of power. So, how do we begin to restore integrity in our legal system? Here are some key reforms, each of which requires detailed and urgent action. 1, reaffirming judicial appointments and promotions must be insulated from political interference. This requires a transparent, merit-based selection process overseen by an independent body, free from executive control. Judges must be empowered to make decisions based on the law and evidence without fear of retribution or repercussions. Number 2, establishing judicial accountability. Parliament must conduct inquiries under Section 72, Sub 2 of the Australian Constitution to identify and remove judges whose conduct undermines public confidence. This includes those who have dismissed cases on obstructing justice for Australians harmed by reckless public policies. Accountability is not persecution. It is a necessary mechanism to restore integrity. Number 3, overhauling the standing doctrine. The abuse of standing as a legal technicality must end. Courts interpretation that recognises the public's rights to challenge government policies that impact health, safety and fundamental rights. This reform requires legislative action to enshrine public interest litigation as a protected category. Number 4, transparency and public oversight. Judicial decisions of significant public interest must be accompanied by detailed explanations accessible to the public. Parliamentary and independent oversight committees should review key judicial rulings to ensure they align with legal principles and public expectations. Number 5, creating mechanisms for who have been denied justice in cases involving preventable deaths and injuries from the COVID-19 non-vaccines must be given avenues to seek redress. This includes the establishment of a dedicated tribunal or commission to hear such cases free from the procedural constraints of traditional courts. And number 6, acknowledging and addressing systemic failures. The judiciary must publicly acknowledge its failures during the COVID era. Truth-telling is a powerful tool for rebuilding trust. Judges and courts must demonstrate their commitment by engaging with affected communities and actively addressing grievances. Finally, trust and integrity cannot be restored in isolation. The public must be engaged as active participants in this reform process. Australians deserve to know that their legal system serves them, not political interests. Until these outcomes are achieved and the ship is righted, we must acknowledge that the social contract in Australia has been broken, repudiated by our judges and most of our politicians. Our elected representatives and judiciary have failed to protect the lives and rights of Australia. The absence of excess mortality in 2020, contrasted with the shocking rise in deaths post-vaccine rollout, demands accountability, demands the truth in acknowledging Australian governments caused these thousands of excess deaths. They are the ones we must confront this reality with courage and resolve. If we fail to act, the consequences will be dire, if they are not already, with so many dead and so many continuing to die prematurely. A legal system that serves power over people is not just dangerous, as it has proven itself to be dangerous. Our democracy, our freedoms, and our future depends on our ability to restore trust and integrity to the judiciary. Let this be our mission, our resolve, and our legacy. Thank you.
Thanks, Julian. That's extraordinary. Very powerful and passionate plea. Read your emails whenever they come through, and they're impassioned, but wow, in person, goodness, thank you. We'll get to go over that subject later in the talk, and anyone ask questions a bit later. Just also to say that I did ask Julian, he was happy for that to be recorded. We know some good defamation lawyers, but But the last two speakers have requested for it not to be recorded because of various issues, ongoing legal cases, etc. And we ask you not to record it as well. Just I should have said that at the beginning. But Augusto, happy to record. So I'm going to... Professor Augusto Zimmermann is our second speaker, and I have the pleasure of introducing him. So Augusto is a law professor and a former law reform commissioner in Western Australia. He's the founder and president of the Western Australian Legal Theory Association, editor-in-chief of the West Australian Jurist Law Journal, former vice president of the Australian Society of Legal Philosophy. He is recognised, like Julian, as a fierce advocate for freedom of speech and the rule of law, and is the author of numerous academic articles and books, including Emergency Powers, COVID-19 Restrictions and Mandatory Vaccination, Law Perspective, published by Connor Court. He will be discussing the role of the Australian Constitution in light of legal decisions during the COVID era and the need and possibility for constitutional reform into the future. Please welcome Augusto. Thank you.
Thank you very much. It's really an honor and a delight to be with you in a very comfortable and pleasant environment. It's not always that I get pleasant environments when I have to talk, especially in academia. So I'm very delighted to be here, and thank you so much for the organizers of this event. I'm extremely grateful for this opportunity. I have posted my paper already on the website. So I'm just going to give you some highlights of what I had to state, which is inevitably controversial in an age of madness. When you try to be normal, you become exotic, perhaps. I don't know. It's interesting, a phenomenon that it's taking place now, that thing will be attacked. Because there are so many doing the wrong things these days. The vast majority of our politicians are doing the wrong things. They're just trying to suppress our free speech at this very moment. Albanese, he is introducing misinformation, disinformation. This is actually to silence us, is to make us slaves of the government. The ancient Greeks used to say that if you do not have free speech, you're not a citizen. So they want to remove democracy now because, of course, free speech is not convenient for interests, if I can put like that, of the ruling classes, the oligarchs that are now in power. So I think my talk is about what we can do to reestablish the rule of law and the legal protection of fundamental rights and freedoms. I'm very the speaker at this moment because Julian Gillespie was preceding me, and I must say that I'm very impressed with him, and I wish we had more lawyers like him with his courage. So over the last few years, Australians have become increasingly serious about Parliament, parliamentarians, and the manner in which the Westminster system operates. The nation's parliamentary system of executive supremacy lies at the very heart of a system that makes government unaccountable and authorizes a vast concentration of power. The responses of the Australian government, federal and state, and so you know that if you read my book called Deconstructing ScoMo, that I wrote together with Rocco Loiocani, you know that I am not so naive to think that Scott Morrison do something for us. He was the prime minister and he allowed all this oppression and tyranny of the premiers. But the primary culprit of that moment in our history was the prime minister, who could have done something to protect us. And I have, in my book, tried to explain what he didn't. So he failed miserably. So the responses of the Australian government, federal and state, to the COVID-19 pandemic had an overwhelming impact on the enjoyment of our fundamental rights and freedoms. These governments exercised coercive powers on a scale never previously attempted. in wartime, when we were faced with a crisis more serious than COVID. The picture we presently see in Australia is of politicians and bureaucrats acquiring a vast concentration of powers. This is destroying my career, even. Constitutional law academic, and the Constitution is being completely destroyed. So the primary characteristic of separation of powers is the assertion of a division of governmental powers or agencies into three different branches: legislature, executive, and judiciary. A more proper, I would say, stricter idea of separation or application of the doctrine of separation of powers can be formulated as follows, and then I'm going to explain what I understood to be a proper separation of powers. It is essential for the establishment and maintenance of political liberty that the government the three branches or departments: the legislature, the executive, and the judiciary. To each of these three branches, there is a corresponding identifiable function of government: legislative, executive, and judicial. Each branch of the government must be confined to the size of its own function and not allowed to encroach upon the functions of the other branches. Furthermore, the persons who compose these three agencies of government must be kept separate and distinct. No individual being allowed to be at the center of more than one branch. In this way, each of the branches will be a check to the others, and no single group of people will be able to control the machinery of the state. This is basically the view that the branches of government should be composed of separate and distinct, with no overlapping membership. The strict doctrine of separation of powers indicates that the mere separation of agencies is insufficient to secure good government. These functions must be placed in distinct hands if freedom is to be assured. Each branch of government is placed in distinct hands. There will be a check to the exercise of power by the state. The idea of constitutional government, by the way, is traditionally associated with this doctrine of separation of powers. Central to constitutional is the conviction that separation of powers may combine governmental efficiency and the greatest possible protection of fundamental rights and freedoms. Charles Louis II, Baron de Montesquieu, was inspired by these teachings when he wrote the Esprit de Loi, or the Spirit of the Laws, in 1748, where he proposes a rigid separation of powers as necessary to protect us against tyranny. According to him, the executive branch, being more rigidly separated from the legislature, can check arbitrary impulses of the latter by refusing enactments that violate principles of the rule of law. Montesquieu commented, and I quote from Montesquieu now, or Montesquieu if you prefer. When the legislative and executive powers are united in the same person or in the same body of magistracy, there can be no liberty. Questions may arise lest the same people should enact tyrannical laws to execute them in a tyrannical manner. Montesquieu also explains that constant experience shows us that every person invested with power is apt to abuse it, his authority as far as it will go. This made him argue that the protection of liberty is far better afforded if the executive and legislative branches are kept more rigidly separated. If one becomes corrupt, the other should be able to check this wayward influence. Well, you think that this is not very British, but Sir William Blackstone agreed with Montesquieu, and he was profoundly influential in England, and he was very influenced, first of all, by the writings of Montesquieu. In his commentaries on the laws of England, Blackstone described the British monarchy as a limited government because the king, lords, spiritual and temporal, and the commons comprised the mutual checks and balances that no longer exist, by the way. And one of the most remarkable passages in Blackstone's book is the one that I read now. And then He was definitely inspired by the teachings of Montesquieu. I quote from William Blackstone now, Sir William Blackstone. In all tyrannical governments, the supreme magistracy, or the right of both of making and of enforcing, is vested in one and the same man, or one of the same body of men. And wherever these powers are united together, there can be no public liberty. The magistrate may enact tyrannical laws and execute them in a tyrannical way, since he is possessed in quality of dispenser of justice with all the power which he, as legislator, thinks proper to give to himself. But where the legislative and executive authorities are in distinct hands, the former will take care not to instruct with so large a power as to many tend to the subversion of its own independence, and therewith of the liberty of the people. And I end quote here. So the classical view of the rule of law that historically guided has been overturned by novel ideas that take no account to the principles upon which the nation was founded. As a consequence, appreciation for the importance of separating the branches of government has been diminished. As Russell Kirk correctly pointed out, since the closing decades of the 19th century, the English Constitution has lost many of the features that Montesquieu and Blackstone had praised at the middle of the 18th century. I can explain a bit of this context. I think we should go to 1714 now. The Hanoverian succession, better say, to the throne of England, of Great Britain, brought about the union between Great Britain and the German electorate of Hanover. Thanks to the settlement, George, the Prince of Hanover, became the nearest Protestant eligible to take the crown of England, of the Great Britain. George found it to be the king of Great Britain a great thing, but he didn't understand the proceedings. And then Sir Robert Walpole volunteered to help him and to act on his behalf, or in effect to become the first prime minister. So the first prime minister is the result of a lazy king who was German and couldn't care less about his kingdom. So throughout the 18th century, now exclusively comprised of members of parliament. That's because Walpole was a parliamentarian. He decided then that all members of cabinet had to be his mates in parliament. This made then the idea that the cabinet is comprised of prime ministers the main feature of the UK system. In a country with no written constitution, but only a collection of statutes, this meant that any statute could now be easily created and repealed by Parliament, even with this, if this were done at the cost of violating fundamental rights and freedoms. The king would remain as, but his executive functions would become either ceremonial or indirectly exercised by the ministers of the crown, who are also members of Parliament. It is in this context that parliamentary sovereignty acquires paramount importance. Sovereignty can be defined as follows. Parliament is competent to make any law or any matter of its choosing, and no court may question the validity of such an act that it passes. According to Lord Beatson, under the classical model of the UK's constitution, no legal limits on what Parliament may do to primary legislation, including altering the period between the general elections and amending or repealing legislation which protects fundamental rights and freedoms. In other words, says Hood Phillips. That's really depressing. But Hood Phillips is the leading constitutional law professor in England that was of the previous century, and he makes this point. He says that there are, under the Constitution of the United Kingdom, no rights strictly fundamental, in the sense of basic inalienable rights because of the supremacy of Parliament and the absence of a written constitution which entrenched provisions and judicial views of acts of Parliament. We have a written constitution in Australia, so I have to forget what I'm reading here because I have to be really quick now. We have a constitution, but we do not have protection of fundamental rights necessarily. And one thing that's very important to say is that the principle or the doctrine, better saying, of parliamentary sovereignty is still valid to Australia, apart from the fact that we have indeed a division of powers between federal and states. Their own heads of powers or freedom to actually legislate on certain subject matters, and the Commonwealth it has other heads of power to exercise. But apart from these, there is no such proper protection. And another thing I must say is that there is no such thing as veto legislation. In Western Australia, the governor now is the former vaccine commander. So it seems that now they are electing to be our head of states the most oppressive characters, people who actually declared war on us, because the word vaccine, the term vaccine commander, tells me that they hate us and have declared war on us. It's time to actually think about what we can do to prevent this sort of affairs. One of the things that I would like to see going is clause Henry VIII or Henry VIII clauses, which basically allows the executive to later. It's not so difficult for this to happen if you bear in mind that those who control the parliament control the executive. I would rather to have as the health minister in Western Australia a person who actually understands the subject and not a journalist, a person who got a degree in journalism of the worst universities in Western Australia. And she has been well known for supporting a culture of death rather than a culture of life. So it's time to put a stop in this madness. There is room for improvement, and there is room for creating a proper system of separation of powers and checks and balances, criminals accountable. I'm not going to be quiet until they go to jail. Thank you very much. Thank you. Thank you. Thank you.
Sorry to cut you off.
No, that's all right.
I'll tell them that the papers are